Hello, everyone. This is Tom Fox back again with Mike D. Bernardus for another episode of the Corruption Files. Welcome back, Mike.
Thanks. Looking forward to it, Tom.
So we're going to continue in the Far East on this episode after having looked at BRIEX in our last episode. And today we're going to look at a scandal involving a company called Hutchison Whampoa Limited from Hong Kong in the early 2000s. This one is a little bit different because there's no bribery, no corruption, no criminal allegations, no significant financial penalties yet. It was a scandal that had huge reputational impact for the company, and we wanted to use it as a way to explore why compliance professionals need to see or be a part of and aware of corporate governance. And I would even say with ESG, focusing on the G part of that, that governance has become something that compliance professionals really need to start thinking about. So with that, the facts are a little bit convoluted, but a billionaire Hong Kongese, back when there was a real Hong Kong, not the faux Hong Kong that exists today, named Li Ka-shing, had multiple, obviously, businesses in Hong Kong. And he decided that he wanted to buy a company called Hong Kong Electric Holdings and to buy it through a company called Cheung Kong Infrastructure. He controlled all of these companies, and so it was almost a related party transaction. This, the fact that he owned both CKI, obviously he owned Hutchison Whampoa, and if he purchased and was successful around Hong Kong Electric, he would control all of these companies. And the scandal highlighted concerns in the corporate governance arena in Hong Kong, particularly around the protection of minority shareholders and companies dominated by powerful individuals and families. Once again, as I tried to articulate, this was not illegal. And we're really not going to talk about the typical fraud that we do on the corruption files, but the controversy attracted significant media attention because of his status as one of the richest men in Hong Kong and indeed in the Far East at that time. And critics alleged that the structure of his company allowed him leverage control over a vast business empire. Mike, when I read this, I was really thinking about Rupert Murdoch. It really gave him control and a way to control companies that had a much broader set of shareholders. And like I said, that compliance professionals need to think about corporate governance. And as ESG has become more ubiquitous, certainly over the past 5 years, governance, the G part of ESG, is both the governance of your compliance program, but it's the governance of your corporation. I was just at a conference where I attended the board track, and almost everyone on the board said the board's job now is risk management. And that if you think of all the things you might think a board might be responsible for, it's really the oversight of risk within the company. And I think that has changed for boards. And now boards have to be able to do that, but they have to understand or know how to do it. In the days of having retired four-star general, a retired secretary of state, a retired bank president, perhaps a dean of a business school, who are obviously very successful people, sometimes brilliant people, but they may not understand risk management and they may not understand the business process. And I think maybe you and I are much closer to an understanding of that. We may not claim to be uh, subject matter experts in corporate governance, but I think we both have an appreciation of risk and how you manage the risk in our respective spheres. I thought it was a good way to talk about some of the current roles of boards, talk about transparency and transactions in a way that compliance professionals obviously know what the safe harbor is under the Department of Justice's safe harbor program for M&A and how we try to think through the merger after acquisition in the compliance. But I really wanted to get your thoughts, Mike, on how should a compliance professional think through corporate governance? Once again, you and I may not be asked to look at corporate governance, but I think in 2024 and beyond, it's going to be a part of any investigation you have or any situation where I'm brought in. So maybe get some initial thoughts and then we can go through some lessons learned.
Sure. Yeah. No, it's interesting. I think I was excited to do this one in part because I have colleagues at the firm who focus a lot on corporate governance. And I think more and more there's coordination between compliance remediation type steps that come out of an investigation and corporate governance. If a company is thinking long and hard about kind of the whole control framework from the very top down. And this gives us a chance to talk about some of those issues that maybe we don't talk about in connection with other matters. One of the things that struck me as I was looking through the materials in preparation for this episode is that for corporate governance, in my experience, the issues that most commonly arise are in the context of perhaps a closely held smaller company, right? That it isn't it quite as sophisticated? It's dominated by one shareholder, a small group of shareholders, and we often see corporate governance issues there. Or a very large conglomerate that has acquired, maybe on a very rapid pace, multiple companies and simply hasn't adjusted yet the corporate governance structure to adjust to the new reality of being involved in different markets and having employees all over the world and having an appropriate structure. This case actually kind of marries the two because in a lot of ways, I mean, Hutchison Whampoa was a massive conglomerate, but it was also closely held. But I think by virtue of its really kind of complex history dating back to the 1800s in terms of changing shareholders, and Li Ka-shing ended up owning a very large block of it, but it was also this huge conglomerate. And so you kind of had a perfect marriage of these two things that I think led to some of the corporate governance issues that frankly could have been a lot worse. I mean, what we ended up with here were some transactions that did not make many shareholders happy and caused some issues. And as you said, some reputational damage. But when you think about some of the concerns that were ultimately raised based on these transactions, the result could have been a lot worse because there could have been some serious problems here, I think, with the way this was structured, could have led to some really serious problems.
I'd like to explore the, if not need, the suggestion for independent oversight at the board level. And so I come out of the energy industry, and at one point, all directors were interlocking.
Mhm.
Everybody sat on everybody else's board, and it was generally good old boys, um, maybe one or two women, but they were all on everybody's board because they were viewed as the women you got for board members. And some very well and prominent women held those roles starting in the 60s going forward. But in because of the interlocking nature of board, there was one positive thing that came out in the energy space, and it was the following. Houston is the FCPA enforcement capital of the world, meaning there are more FCPA enforcements and investigations in Houston than any other city on earth, and that's because of energy. But what that did was give a very high profile to FCPA, and people who were on boards had to endure an investigation and certainly the cost of an investigation. And the senior executives who became the interlocking directors across other companies also had that experience. It led to almost every company had board members who either directly had a enforcement action against their company or had gone through an investigation. And that allowed these companies, who sometimes were portfolio companies of private equity or private equity companies that were smaller and energy focused, to have not only an appreciation of compliance, but also understand that a compliance program was needed in a company. So it was many ways easier to get that into companies starting in sort of '08 going forward after the first wave of enforcement actions against energy companies. That's the only way I can think of an interlocking directorate was positive. And now I think both the DOJ and SEC have actually started looking at that issue is, and let's just stick with energy. Is that really independent oversight to have other subject matter experts from other energy companies on your board, or do you really need to bring someone in from outside in your?
It's a great question. I think of independence at the board level from multiple aspects. One is the issue of interlocking directorates, which with Section 8 of the Clayton Act is an issue, and companies have to be careful with dealing with clients on this issue. I have found some frustration in that sometimes the experienced board members that they would want are experienced because they are currently members of other boards of a perhaps it's competitor. It doesn't even necessarily have to be a one-to-one competitor. I mean, the energy industry is one thing. If you sit on the board of Shell, maybe not sitting on the board of Exxon, but there's other industries where your competitors are less clearly defined. But you want somebody who's got industry experience, and it can become tricky with the prohibition against interlocking. I do think of independence in that way, and I think a lot of people are on the fence about how the benefits of actually having folks who have that experience and are sort of staying at the industry level on multiple boards. I also think of independence from the perspective of being independent from powerful executives or shareholders of the entity you are serving on the board of. This is also a tricky issue. In some ways harder to identify and define because you can have people who would on paper seem to be totally independent, but were handpicked by a powerful executive or shareholder to sit on the board, or, maybe lifelong friends, or just feel a debt of gratitude to that person such that they're not really acting in an independent capacity when it comes to making board decisions, rather acting as a rubber stamp of sort to whether it's the CEO or a powerful shareholder. And I think both, as you're structuring a board, both things are critical. I think it is important in a lot of ways to find board members who have relevant expertise in the industry, especially in some industries. Energy is one. I think of aviation as another. Some places where there are nuances to the industries, such that having that expertise can be critically important. And in other ways, I think you want to find the expertise that is ensuring you have independence, really having free thinkers on the board who are simply looking out for the best interests of the company and the shareholders, and free from pressure from executives, sort of larger shareholders and that sort of
A couple of examples. When I was at Halliburton, the Robert Crandall, who had been the CEO at American Airlines, was appointed to the board. And he came in, obviously had some experience with energy because that's one of the biggest costs of airlines, but he was not from a producing company and he really shook things up. It may have been just his personality, but I mean, he was down with our internal auditors, telling them questions to ask the legal department because they came and asked me. And that was not something we'd ever have a board member do, get down into that level. But, 20 years later, I see that sort of new blood coming in shook things up. And that was what the internal audit team needed, not only to ask the right questions, but to give them confidence that they had a board member who had their back, basically, even if he was asking tough questions. The the flip side is Bluebell Ice Cream. And you'll, of course, remember the Marchand case in corporate governance. There's another part of that case that rarely gets discussed, though, and it was that the shareholders and the shareholder derivative action sued Bluebell for having interested parties on the board. And Bluebell was in a group, was from a small town called Brenham, Texas. And the family that owned Bluebell was one of the richest families in the town. And the board members all had business relations with him. One person, he had financed a book they had written. One person taught at a local college, and he was the largest donor. And they all socialized together at the club, of course. And the court went through literally almost an expenditure, but high expenditure analysis to determine whether or not they were truly independent. The court didn't, shareholders were not successful on that part of their lawsuit. But when the first three listeria deaths came out, the first thing they did was pass a resolution about what a great job the CEO had done. And it was just an unmitigated PR disaster. I think courts are sensitive to that. And you can see where if board members are really beholden to a CEO, it can seriously hurt the company.
Yeah, absolutely. That independence from the CEO, or like I said, a powerful shareholder, is in a lot of ways to me. And as we talk about related party transactions, I think this becomes even more the most important piece of independence. You want somebody who's not looking out for the executive, is not necessarily in the pocket, so to speak, not literally, but just feels beholden to the person proposing ideas or managing the company, and is really exercising that independent oversight. That's the purpose of a board, is to exercise independent oversight over the executives, right? That's what they're there for. Somebody's got to be the boss of the boss. That sort of independence to me is more critical than perhaps being independent of sitting on a competitor's board or another other boards in the industry, as you mentioned before, because you really want somebody to, and that type of independence support from a competition perspective and making sure we don't have this sort of collusion that's plagued certain industries from time to time. But when we're talking about corporate governance and ensuring that transactions that the company steps the company takes are really in the best interest of the company and it's all of its shareholders rather than a certain subset, that free thinking is critical.
And then there's another area I wanted to explore with you, and really from the compliance perspective and its internal controls. And while I don't think a lot of compliance professionals think of transactions in the internal control context, if you really step back and think about it, it's a business process. You're going through it, and there are multiple internal controls. So if we look at the DOJ safe harbor for M&A program, it is you need to do a risk assessment pre-acquisition, post-acquisition. You need to incorporate the acquired company into your compliance program. You need to do a forensic investigation and turn over the results to the Department of Justice if appropriate, and then train the new employees from the acquired company under your compliance program, assuming you're going to incorporate them into yours. And that's a process. And it may seem like a big process, not subject to internal controls. But here I'd like to suggest that the controls are a process to track each step of the transaction in terms of an evaluation so that there's an audit trail to protect the company. Really, any thoughts around that, or is that something different in your mind?
No, I think you're exactly right. I've said it on this podcast and others that I think documentation is critical, right? It's annoying, I know, for a lot of compliance professionals and others, but sort of creating that trail of what's been done that can be audited 5 years later is absolutely critical. I think you're right. I think when I think from a corporate governance perspective and then internal controls, what a compliance department can realistically do. I think the reality is a compliance professional, even the CCO, it has a lot more say potentially over the stuff you just mentioned in terms of integration and creating these audit trails for when we're acquiring companies and setting up the new structures. The asking a compliance professional to have a major impact on the structure of the board of directors is a much harder sell. It's not their role. They can provide advice. But one of the things I think can be done, and it can be done at various times, whether that's after an acquisition or a major corporate transaction, is training for the board of directors. And it's a helpful reminder to the board about their role in an independence basis, what we were just talking about. It's also a helpful reminder about what the expectations for the company is after we've done this transaction, after we need to do this integration, take these steps, and your role on the board for helping us ensure that this is done appropriately. And in my experience, every time a training for a board of directors has been proposed by senior compliance professionals, the board's open to it. They want it. So I think it's a really useful tool and a useful way for compliance professionals to remind the board of their specific individual roles, and also remind them of what the company needs to do downstream. So that they're thinking about it as they're going. The audit committee of the board of directors is meeting and thinking about, making sure that appropriate resources are dedicated to doing these integrations and to making sure that the newly acquired company has appropriate internal controls in place and is aware of and thinking through those issues in a specific way rather than just at a very high level general thought of, oh, I hope we're integrated.
And that's really the point I wanted to use to in this podcast to talk to compliance professionals about compliance's role in the G of ESG, because this is up the chain. This is compliance training the board. And you're absolutely spot on that this is, I mean, I've had board members say, will you please train us on our role? How do we do oversight for compliance? Because how do you do oversight for governance? And giving all of this information to the board is absolutely critical. Although you and I probably have done board training on FCPA, I'm not sure that's really the top thing they need.
Yeah.
Because they probably received it somewhere else.
Yeah.
It's probably not bad to have a refresher, but what they really need is what you just said. How do we engage in this oversight? How do we protect the company? How do we demonstrate that we are managing this risk? And I think a compliance, a CCO or other compliance professional is well suited to give that training to the board, really independent of senior management, so they understand their role in that in a way that could satisfy the G part of ESG.
Yeah, absolutely. And I think in my experience, many of the corporate governance issues come up because a board of directors loses focus about what their role is, perhaps was never really received direct instruction as to kind of what their role is. And then having these reminders about independence, about oversight, about asking the right questions, that's all they need, right? To say, oh, you know what, actually, we're supposed to be independent. It looks like the board's really cozying up to the CEO too much. Let's take some steps to make sure we back off of this. Or this transaction is a related party transaction. Let's take these 5 steps to make sure we're maintaining independence to be able to weigh in on this decision in an appropriate way. Or we have independent advisors, which I always say is one of the most important things with related party transactions, is make sure you have independent legal counsel, independent financial counsel to really, again, on paper, very much create an audit trail that shows that the independent look was given to this transaction. But they're open to it 99% of the time, and eager for that training and react really positively to it.
Well, Mike, unfortunately, we're near the end of our time for this episode. I hope the compliance professionals listening to this enjoyed thinking about a case a little bit different than our typical case, but I really enjoyed exploring some of these issues. So I can't wait to see what we come up with next time.
It was great. Thanks, Tom.